People always say they do the right thing. They say it at dinner tables, in church pews, in courtrooms. They say it with the easy confidence of someone who has never had to choose between justice and the person they love most. I used to say it too, with that same confidence, that same certainty, until the right thing cost me everything I had spent a lifetime building. The day I was appointed to the family court bench, my son Marcus stood in the front row and clapped the loudest. He was 19 years old, gap-toothed smile, his father's eyes, wearing a tie he'd clearly borrowed from someone because it was 2 inches too short. I remember looking out at that courtroom, at all those faces, and finding his first. I thought, I am doing this for him. I am building something he can be proud of. Something that will outlast me. That thought would follow me, like a shadow for the rest of my life. 31 years in this office teaches you one thing. Above all else, everyone believes their project is the right one. Coworkers, partners, managers, and clients all sit across from you with the same expression, focused, ready, and certain that if you just understood the full picture, you would see it their way too. I had looked that expression in the eye thousands of times and never flinched. I never thought the day would come when I would recognize it on my own son's face, sitting at my kitchen table, hands wrapped around a coffee mug like he was just visiting. Marcus started Sycamore Gardens with hard work and long hours to create a care facility for elderly residents on the east side of the city. He called me when it opened to share his pride in the project. I visited the next morning and saw the staff greeting residents by name while Marcus spoke kindly with a veteran. I felt proud of what he built, and I supported his work completely. The call from Detective Harlan came on a Tuesday morning while I was reviewing case files for a custody hearing that afternoon. He didn't ease into it, didn't offer condolences or qualifiers. He was the kind of man who respected you enough to be direct. Judge Mercer, your son is under active investigation for systematic financial fraud against residents at Sycamore Gardens. We're looking at over $200,000 redirected from patient accounts across 18 months. The fluorescent light above my desk buzzed faintly. My pen was still in my hand. I set it down very carefully, like the wrong movement might shatter something, and I didn't say a single word for a very long time. I didn't confront Marcus that night. I didn't call him, didn't text, didn't reach out at all. Instead, I drove to Sycamore Gardens alone, told the front desk I was doing an informal welfare check, a thing judges occasionally do, and walked those corridors for 40 minutes. The place smelled like cafeteria food and floor wax and something faintly medicinal. An old woman in room 7 saw me lingering in the doorway and waved me in. She asked if I was someone's mother. I said yes. She told me the staff was kind, that she felt safe there. I smiled at her and left before she could see what was happening behind my eyes. The evidence the prosecution assembled was precise and devastating. Forged consent forms bearing residents' signatures, a shell account traced directly to a laptop registered in Marcus's name, 18 months of wire transfers, each one small enough to avoid automatic flags, each one documented and time-stamped. My colleague Judge Whitmore recused himself the moment the case came to our courthouse. He'd had dinner at my home twice, and it was assigned to Judge Adisa, who had a reputation for patience and absolutely no tolerance for financial crimes against vulnerable populations. He was exactly the kind of judge I had always admired. That didn't make it easier. 3 weeks before trial, 2 prosecutors came to my office and sat across from me, the way defendants usually did. They were professional, almost uncomfortable, which told me they understood exactly what they were asking. They explained that I was their most valuable potential witness, not because I had direct knowledge of the fraud, but because of what Marcus had said to me over the years, without realizing its significance. Offhand comments about restructuring patient fee agreements, a remark at Christmas dinner about building in administrative flexibility for operational costs, words I had heard and filed away as business talk. Words that now, laid against the evidence, formed something that looked a great deal like a confession, in pieces. My attorney told me I had every right to decline. "You are his mother," she said, leaning forward, like she wanted me to really hear it. "The court will understand. No one is going to fault you for protecting your child." I sat with that for 3 days. I did not sleep much. I pulled the statements from the case file and read every single one. An elderly man who went without his medication for 2 months because his account showed insufficient funds. A woman whose family moved her out in a panic only to discover she had been telling the truth for 6 months, and no one had listened. They had names. They had faces. They had been inside the building my son built with pride and called something real. Marcus came to my house the Sunday before trial was set to begin. He sat at my kitchen table, the same table where he'd done algebra homework, where we'd fought about curfews and college applications, where I'd told him one quiet evening that his father wasn't coming home, and he looked at me with something that wasn't quite desperation and wasn't quite anger, but lived somewhere between the two. "Mom, don't do this," he said. "Whatever they told you, whatever it looks like, I can explain it. Just don't get on that stand." I told him to explain it right then, right there, at that table where I had never once lied to him. He looked down at his hands. He didn't say another word. I took the stand on a Wednesday morning with the courtroom fuller than I'd expected. I answered every question the prosecution put to me, clearly and without hesitation, because I had spent 31 years sitting above that exact process and demanding honesty from people who desperately wanted to give me anything else. I was not going to become the thing I had judged. Marcus sat at the defense table 10 feet away and did not look at me once during my entire testimony. Not when I confirmed his words. Not when I identified his voice on a recorded call. Not when I stepped down. As I walked past him, I heard someone in the gallery say it quietly, but not quietly enough. Cold. I kept walking. Maybe they were right. Or maybe they had never been the person who had to decide what justice actually costs when the defendant shares your last name. The verdict came back in 11 days. Guilty on 4 counts of financial fraud, 2 counts of elder abuse by exploitation, and 1 count of forgery. I was in my chambers when my clerk told me, her voice carefully neutral, the way young people get when they don't know how to handle someone else's grief. I thanked her and closed the door and sat very still for approximately 20 minutes. Then I washed my face, straightened my robe, and went back to the bench for a 2 o'clock hearing. That was the only thing I knew how to do. Marcus finished his project 6 weeks later at a remote office site outside the city. I did not attend the meeting. My sister called me that evening, and I let it go to voicemail. My brother-in-law sent a text that said 3 words, "Are you finished?" I read it twice, set my phone face down on the counter, and poured myself a glass of water because my hands needed something to do. Finished. As though that had ever been the word for any of this. The family fractured the way old structures do, not all at once, but in stages, each one quieter and more final than the last. My sister stopped returning calls within the first month. Marcus's aunt, a woman I had known for 40 years, sent me a letter so precise in its contempt that I had to admire the craft of it even as I read it. The people who had celebrated my appointment to the bench, who had toasted me at retirement parties for colleagues, who had called me principled and brave, they went quiet in the specific way that tells you they've already made their decision and don't want to debate. The court community was different. Colleagues shook my hand in hallways with a particular firmness, the kind that means something. Legal journals ran 2 separate pieces about prosecutorial ethics and the role of family testimony in financial crimes cases. Neither mentioned me by name, but both used language that made the subject unmistakable. A law professor I'd never met sent a letter to my office calling my testimony a defining act of judicial integrity. I kept the letter in my desk drawer and took it out exactly once, read it, and put it away again. It did not make me feel what he thought it would. I visited Marcus for the first time 4 months after his sentencing. The facility was cleaner than I expected and quieter than I feared. He came into the visitation room and sat down across the scratched plexiglass and looked at me the way you look at something you're still deciding whether to forgive. We talked for 40 minutes about nothing, the food, the other residents, a book he was reading. He did not mention the trial. I did not mention it either. When the guard signaled time, he stood up and said, without looking directly at me, "I know why you did it." He walked out before I could ask him what that meant. I turned that sentence over in my mind for months. I know why you did it. It could have meant he understood. It could have meant he had accepted it. It could have meant something colder. That he had simply categorized me, filed me under a heading, and moved on without me. I had spent 3 decades reading people in courtrooms, and I could not read my own son through scratched plexiglass. That felt like a punishment more specific than anything Judge Adisa could have handed down. 13 months after the conviction, a name appeared in a document that shouldn't have crossed my desk, but did. A colleague flagged an appeal filing in an unrelated fraud case, standard procedural routing, and buried in the supporting exhibits was a name I recognized instantly. Diane Forsyth. Marcus's former business partner, the woman who had left Sycamore Gardens 8 months before the investigation began, the woman I had met exactly twice and found precisely as charming as people find others when they are performing charm rather than feeling it. Her name was in a financial disclosure that did not match what she had told investigators during Marcus's trial. I did not act immediately. I sat on it for 2 weeks, which I am not proud of, because sitting on information is not something I had ever permitted myself professionally. But this was different in a way I kept trying to articulate and couldn't quite reach. If Diane Forsyth had lied, if the money trail went somewhere other than where the prosecution had pointed, then what I had testified to was still true. But what it had meant might be something else entirely. Truth and context are not the same thing. I had built a career on knowing that. I had apparently needed to relearn it at 63. I asked an outside expert to review the files while keeping my involvement private, and within 3 weeks, they found data that the first team missed because they were not asked to check those specific records. They found extra accounts and transfers that happened before the ones Marcus was linked to, which came from a computer at a firm that Diane Forsyth closed shortly before she left the company. The new information did not show that Marcus was innocent, but instead showed that he knew about the situation and accepted responsibility for his part, while the main plan was managed by someone else. I drove to the prison on a Thursday with no appointment, which meant I waited 2 hours in a beige room before they brought him out. When Marcus sat down and saw my face, something shifted in his. Not relief exactly, not vindication, but the particular exhaustion of someone who has been carrying a weight alone and has just seen someone else finally pick it up. "How long did you know?" I asked. He said, "Long enough that stopping it felt like burning everything down." I asked him why he hadn't told me. He said, "Because you would have done exactly what you did anyway, and at least this way she didn't walk away with all of it." I sat with that for a long time. I'm still sitting with it. Marcus did not follow the process, and I want to be clear about that, because accuracy is important. He knew about the project Diane created and took part in it. He let the work continue for too long, and then tried to manage the results in a way that supported her more than it supported the team or the residents. The people who had issues had them, no matter whose idea it was at the start. That fact does not change. However, the report the board heard, and the report I helped write, had only one person to note. The actual person who created the project was at that time working from a home office in another state. That person was not contacted or asked to explain and seemed to be doing fine. I went back to my contact and shared the new project details, and she paused to think about the situation before saying that this update would change how my report is viewed because it adds new context to the work. I told her I understood, and she asked if I was ready for how that would look to the team, since a person who previously held a different view would now appear to change that position. I told her that I had shared the facts as I knew them at the time, and I explained that the project had since grown, and my only job was to follow the new data wherever it led. The referral went to the DA's office on a Friday afternoon. I submitted it personally, in writing, with every document the investigator had compiled, and I attached a cover letter that took me 4 drafts to get right. I did not frame it as exoneration. I framed it as incomplete prosecution. The response from the DA's office came back in 10 days, carefully worded, professionally neutral, the kind of language institutions use when they are deciding whether a problem is big enough to require action or small enough to require silence. I had written that language myself, years ago, in different contexts. Recognizing it did not make waiting for their answer any easier. After I sent that report, I sat at the table where Marcus and I had talked, and I thought about my long career. 31 years of making choices. 31 years of asking people to trust that the office process would lead to fair results. I still believed in that. I believed it like something you have tested and improved many times. But I also understood while sitting in the quiet house that the office process and the facts do not always move in the same direction. When they differ, someone has to decide which one to follow. I had made that choice twice now. I still did not know if I had made the right call either time. The office started a second review of the files for Diane Forsyth 6 weeks after I sent the report, and they did not call me to talk about it. I heard from my legal contact in a short note that the financial data was clear enough to require more study. There is no final result or date yet. The process is just moving ahead at its own pace while I wait for more news on the status of the project. Diane was indicted on a Thursday morning, 14 months after I submitted the referral. 3 counts of financial fraud, 1 count of conspiracy, and 1 count of obstruction for the false statement she had given during Marcus's original trial. I found out from a news alert on my phone while I was standing in the cereal aisle of a grocery store. I stood there for a moment between the shelves, the fluorescent light the same cold white as every courtroom I had ever worked in, and felt something I couldn't immediately name. It wasn't satisfaction. It wasn't relief. It was something closer to the feeling you get when a very long storm finally breaks. Not joy, just the strange, exhausted quiet of after. Marcus's legal team filed for a sentence reduction 2 weeks after Diane's indictment, citing the new evidence and its direct relevance to the original case. The DA's office did not oppose it, which, in legal terms, is as close to an admission as institutions ever get. Judge Adisa reviewed the filing and reduced Marcus's sentence by 14 months. He would be eligible for release in 63 days. My attorney called to tell me, and when she finished, I thanked her and set the phone down and did not move for a while. 63 days, 4 years of wreckage, compressed into a number small enough to fit in a sentence. I wrote Marcus a letter the day after the reduction was granted. I had started it 7 times over the previous year and abandoned each attempt because nothing I put on paper felt honest enough or complete enough or equal to what the moment required. This time, I didn't try to make it complete. I told him what I had found and when I had found it. I told him what I had done with it and why. I told him that I did not regret testifying against him, and that I also did not regret spending 18 months trying to make sure the full truth got into the room. I told him those 2 things could both be true at the same time, and that if anyone understood that, It should be the son of a family court judge. I sealed it before I could read it back. He called me from the facility 3 days after the letter arrived. We talked for an hour and 20 minutes, which was longer than we had spoken in 2 years combined. He was not warm exactly, not the way he used to be, but he was present in a way that felt like the beginning of something, rather than the performance of it. At one point he said, "You know what the worst part was?" I told him I didn't. He said, "Knowing you were right and hating you for it at the same time." I told him I understood that, feeling better than he might think. He laughed. Once, short and dry, and neither of us said anything for a moment. That silence felt more like progress than anything else in the entire conversation. Diane Forsyth finished her project 8 months late to avoid problems by accepting a 5-year plan that allowed for early completion. Her lawyer released a statement saying her actions were due to budget limits after a hard time. This was meant to explain the situation clearly. I read the statement once and did not comment publicly, even though several coworkers expected me to. I had nothing to say that the project documents did not already say better, and without my personal feelings changing the facts. Marcus was released on a Tuesday in early spring. I drove to the facility alone and waited in the parking lot in the gray morning light. When he came through the doors, he was carrying a single bag and wearing a jacket I didn't recognize, and he looked older in a way that had nothing to do with time and everything to do with weight. He saw me and stopped for a moment on the walkway, just stopped, and I got out of the car and we stood there in the cold for a second before he closed the distance. He didn't say anything, neither did I. Some things don't have words that fit them, and after 31 years of demanding precise language from everyone who stood before me, I had finally made peace with that. The legal community's reaction to everything that followed was, predictably, divided. Several colleagues called my handling of the referral a model of ethical consistency. The same integrity that had put Marcus in prison had also worked to correct the incomplete picture that put him there. Others were less generous, suggesting that a judge of my standing should have found a way to surface Diane's involvement earlier, during the original investigation, before the verdict. That criticism has some merit, and I don't dismiss it. The honest answer is that I didn't know what I didn't know, and when I found out I acted, and the gap between those two moments is something I will carry, regardless of how anyone else chooses to categorize it. Marcus and I have dinner most Sundays now. We don't talk about the trial often, and when we do, it's in the way you talk about a scar, acknowledging it's there without needing to reopen it. He's working with a nonprofit that advises families navigating elder care decisions, which strikes me as either deeply ironic or deeply right, depending on the day. He told me recently that some of the families he works with have heard of his case and ask him about it directly, and that he tells them the truth, all of it, because he's found that the incomplete version helps no one. I didn't say anything when he told me that. I just looked at him across the table and thought about how strange it is, the way people become themselves. I still believe I did the right thing the first time. I also believe that the right thing, done inside an incomplete picture, can produce an unjust result, and that those two facts coexisting is not a paradox to be resolved, but a tension to be lived with. Justice is not a clean mechanism. It is a process built by human beings who have limited information and unlimited certainty, and it requires constant correction by people willing to be uncomfortable enough to keep looking after the verdict. I have spent 31 years asking others to trust that process. I am still asking. The difference is that now I understand, in a way I didn't before, exactly what that trust costs.